Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk. Today, I am going to be giving you guys more clarification in regards to Chrisean'S Oklahoma case, specifically the application to accelerate default judgment due to her violating her uh, parole. Oh, no, I'm sorry, her probation. There has been a lot of questions that have been asked under posts that doesn't even have anything to do with Chrisean or just her civil matters. I've seen on various YouTube pages as well as TikTok pages saying that she's going to get up to 30 years, or asking me if is it true she's going to get 8 years. And I'm just like, where are people getting this information from? So today's video is going to go over her charges, going to cover the criminal statute or sentencing for those particular charges. We're going to go over what an application for deferred judgment is, what the deferment is, what happens when you violate the deferred sentence, so on and so forth. So I want everybody to be able to feel a little bit better when it comes to knowing what can possibly go on with Chrisean. As we know, she is in Los Angeles County right now. She hasn't been extradited to Oklahoma. I have not seen any updated jail records reflecting that she is there. With that being said, let's hop on into this. I had to make some notes because I just want to make sure that I do this in a timely manner, but I don't leave anything out. So, first and foremost, I do want to go over Chrisean'S charges. So, let me first pull up her case. So, I am taking you guys to the court docket for Craig County to kind of go over. So when the state initially filed this back in 2022, they, you know what, it's right here, but I'm gonna pull it up. Okay, let's do this. All right, so we have count one and count two. First count was unlawful possession of controlled drug, marijuana, with intent to distribute, and it has the section code right here. Then count two, same thing, possession of CDS without tax stamp affixed, along with the section code. Both of these was a felony. Now I'm going to take you guys to the actual statutes for each of them so we can determine what sentence the sentence is for each charge. And I'm going to swap so you guys can see this. So going back here, we have, what is that? 2401 paragraph B2. So going down to B, so here is section B. You know what? Let me make this bigger. Here is section B, or paragraph B, and here's 2. So for the unlawful possession of controlled drug, marijuana, with intent to distribute, it says any other controlled dangerous substance classified in Schedule 3, 4, 5, or marijuana upon conviction shall be guilty of a felony and shall be sentenced to a term of imprisonment in the custody of the Department of Corrections for not more than 5 years, and a fine of not more than $20,000, which shall be in addition to other punishment provided by law and shall not be imposed in lieu of other punishment. If there is a second conviction for this provision or this violation of the provisions of this paragraph, that is going to be a felony punishable by a term of imprisonment in the custody of the Department of Corrections, or DOC, for not more than 10 years. If there is a third or a subsequent conviction for the violation of provisions of this paragraph, it is a felony punishable by the term of imprisonment in the custody of the Department of Corrections for not more than 15 years. So as you keep violating the same thing, the terms the terms increase. For Chrisean, she is going to fall under this first portion of the paragraph. So that means that it is up to the judge. This is just showing you the consequence for doing this offense. It is not saying that the judge is just going, because it says that she's going to go to jail for 5 years and he's going to throw $20,000 for her as far as fines. That does not mean that. It's saying that the judge has to sentence her within those boundaries. So no more than 5 years and a fine of no more than $20,000. That is for the first charge. So the judge has to work within those conditions. The second charge was the possession of a CDS without tax stamped affix. And let's see, this is 450.8 and that's B. So I'm going to get out of this one. All right, so B, here is B right here. Any dealer manufacturing, distributing, producing, shipping, transporting, importing, or possessing any controlled dangerous substance without affixing an appropriate stamp upon conviction is guilty of a felony, punishable by imprisonment in the state penitentiary for not more than 5 years, or by the imposition of a fine of not more than $10,000, or by both such imprisonment and fine. So this one also carries more than not more than 5 years or a fine, or it could be both. And that's for the second count. So going back here, let me just make sure. Yeah. So going back here, I'm going to exit out of this and we are going to go to the day that she accepted the plea. So I'm going to bring this one up first. Yeah, verify, verify. What? Y'all, forgive me. Just clicking a little bit too fast. Blowing this up, as you can see, the judge deferred. So he sentenced 5 years, but he deferred it. And she was to be supervised by the Department of Corrections. He also how can I say, ordered her to pay $3,000 to the drug fund. And so here, in accordance with 991 A, paragraph A1, you are hereby ordered to pay the prosecution reimbursement fee in the amount of $40 per month for the first 2 years of probation. The first payment is to be paid within 30 days of your plea. So this is the original sentence, okay? Clicking out of that, and I am going to go to the actual deferment. I'm going to pull that up. And we are going to go back here so we can get a lesson on a deferred sentence. So why is it that the judge ordered for her to have a deferred sentence? So upon a verdict or plea of guilty, or upon a plea of nolo contendere, but before a judgment of guilt, the court may, without entering a judgment of guilt and with the consent of the defendant, defer further proceedings upon the specific conditions prescribed by the court not to exceed a 7-year period, except as authorized under section B of this subsection B of this section. The court shall first consider restitution among various conditions it may prescribe. The court may also consider ordering the defendant to pay court costs, pay an assessment in lieu of the fine authorized by law for the offense, pay any other assessment or court authorized cost authorized by law, engaged in term of community service without compensation according to a schedule consistent with the employment and family responsibilities of defendant, county jail confinement of a period not to exceed 90 days, or the maximum amount of jail time provided for the offense if it is less than 90 days. Pay an amount as reimbursement for reasonable attorney fees to be paid into the court fund if a court appointed attorney has been provided to defendant. Be supervised in the community for a period not to exceed 18 months unless a petition alleging violation of any condition of deferred judgment is filed during the period of supervision. As a condition of any supervision, the defendant shall be required to pay a supervisory fee of $40 per month. The supervision fee shall be waived in whole or part by the supervisory agency when the accused is indigent. Any fees collected by the district attorney pursuant to this paragraph shall be deposited in the general revenue fund of the state treasury. No person shall be denied supervision based solely on the inability to the person to pay the fee. Pay into the court fund a monthly amount not exceeding $40 per month during any period during which the proceedings are deferred when the defendant is not to be supervised in the community. The total amount to be paid into the court fund shall be established by the court and shall not exceed the amount of the maximum fine authorized by law for the offense. 9. Make any reparations to the community or victim as required and deemed appropriate by the court. 10. Order any conditions which can be imposed for a suspended sentence pursuant to paragraph 1. She does not have a suspended sentence, she has a deferred sentence. Suspended sentence means once you finish, then it's going to go on your record. Deferred sentence means that once you finish, you have the opportunity to expunge your record. And then any combination of the above provisions. So that is deferred sentence. So here, as you can see, they gave her 4 years. So for each count, they gave her 4 years until March 15th, 2027. It's not 8 years, it's not 30 years, it's not 15 years. It is 4 years that's running concurrent. So by March 15th, 2027, she would have completed her probation. In addition to her deferred term, the judge also ordered special rules and conditions, because remember we just read that the judge can add conditions if need be. She had to be placed on Department of Corrections supervision. He told or ordered her to complete 120 hours of community service in lieu of 30 days in jail, and it had to be performed at a homeless shelter. And he also ordered for her to pay $991 to the district attorney's office. He also ordered for her to pay a fine for each of those charges. So for count 1, a $3,000 fine. For count 2, a $500 fine. Because remember, for count 1, no more than 5 years and a fine of not more than $20,000. For count 2, no more than 5 years or a fine or both. He gave her probation for 4 years on each with special conditions. And then cost VCA and restitution. Okay? Um so that is all on that. So I want y'all to see what her deferment was. Now, how do I want to do this? What happens if you violate your deferred sentence? I'm going to scroll to G, and here's G. It says, upon any violation of the deferred judgment, other than a technical violation. So, a technical violation is a failure to check in or doing your monthly drug, whatchamacallit, that is considered, just like what Blueface got. They made it a technical violation. But so upon any violations of a deferred judgment other than a technical violation, the court may enter a judgment of guilt and proceed as provided in section 991A, or they may modify any condition imposed. However, if the deferred judgment is for a felony offense, and the defendant commits another felony offense, the defendant shall not be allowed bail pending appeal. All right, so that's what happens according to Oklahoma. This is Oklahoma statute. This is what happens. So now we're going back to this case, Chrisean'S case, and we know that they submitted an application to accelerate deferred sentence. And we have read this numerous amount of times. So we know that Chrisean asked for the probation to be transferred to California. We know that Chrisean was supposed to go to orientation and check in and supply the PO with certain information. And she didn't. This application also stated that she violated her probation by getting another charge in Maryland with the Vicky case, as well as the James Wright incident. So in this application, as we have gone over based off of the violation reports, I'm not going to go through those again. This application stated everything that Chrisean has done to violate her probation. Now, what is an application for application to accelerate? And I'm going to blow this up because y'all know I have to do my notes so I won't leave anything out. So in Oklahoma, an application to accelerate is a formal document filed by the DA's office that asks the court to impose the original sentence for a deferred sentence. It can be filed if the defendant has violated their probation, or if they cremated committed a crime while on probation and they're still within their deferral period. They submitted their application based on the fact that she violated her probation by not checking in, by not going to orientation, by not, the reasons. And they also included the other incidents with the Maryland and Los Angeles. You guys know. Now, anytime you file an application to accelerate, that requires a hearing. The DA's office has to prove that the defendant violated their probation. So that's why in that application, you see the incident reports from the James Wright case. Now, I didn't see anything for the Vicky case, but I seen it for the James Wright case, and so I'm sure that they were following up with that case. In addition to that, they showed the numerous rules that she violated. And when I say numerous rules, meaning that she didn't check in, she didn't provide an accurate, up-to-date address, so on and so forth. All of those would be considered a violation. What is the outcome when you file an application to accelerate? It can vary, but it can end up in a hearing. It can end up in a confession, meaning that they will provide the defendant an opportunity to confess everything that's stated in the application. They can be reprimanded. The probation can get extended, and it can also result in jail time. Now, going to the court docket, as you can see, They submitted the order of the application on let's see, that's February 23rd. An order was also submitted on that same day. So the judge had to pretty much look at all of this to make his determination. Also, in the application, remember that they mentioned the James Wright case, and they advised that they are going to supplement the they were going to supplement the what you call that, the report for James Wright, and they supplemented on the 28th. But going back, I want us to take a look at the order. The judge, anytime you go before the judge in a hearing, this is the outcome. They're going to review everything that the counsel brings forth. With that being said, it stated that on February 23rd, 2024, the above entitled matter comes before hearing as to the defendants. Failure to complete 120 hours community service by September 15, 2023, as ordered on March 15, 2023. Also, she violated the community service rules as follows. She failed to comply. So she failed to comply, and she still had a remaining balance of 120 hours of community service. The court, upon hearing the merits, so whatever the state brought to them, plus reviewing the file, that means reviewing the application in its entirety, also noting that you see this individual has had a case, well, at the time has a case in Maryland and had a case in Los Angeles. So he has seen all of this. She also failed to complete community service according to the rules as ordered. So, based off of everything that the DA has told the judge and the judge reviewing everything, he concluded that she failed to complete community service according to the rules as ordered. It is therefore ordered that the defendant be committed to the custody of the sheriff of Craig County, Oklahoma, and to be jailed for 30 days of flat time as previously ordered. That's it. There's nothing other than this. So what I have been saying this whole time was that I was waiting for this to be updated, in which it doesn't have to be updated because the judge already made his ruling based off of the information that was presented to him. I hope y'all are picking up what I am putting down. So, with that being said, please let me know if you have any questions. Don't forget to like, comment, share, and subscribe. Hopefully, I will see you guys later. But until then, be blessed. I'm out.